Hello. Today, I recently watched a very insightful video titled Termination of Contractor's Employment by Employer. I'd like to share the key takeaways from the video with you all today. The speaker begins by emphasizing a very important principle in construction law. Termination of a construction contract is a serious matter. It cannot be done arbitrarily. If an employer wishes to terminate the contractor's employment, it must strictly follow the procedures and grounds provided under the contract. In Malaysia, there are several standard forms of contract, such as PAM, CIDB, PWD, and FIDIC. Each contract has its own clause that lists down specific grounds for termination, such as failure to commence work on time, unjustified suspension of work, not progressing diligently, failure to follow the instructions of the consultant or architect, persistent breach or abandonment of site. The speaker explains that termination is only valid if notice is given properly. This includes 1. A warning notice, giving the contractor a chance to remedy the default, and 2. A formal notice of termination only after the contractor fails to correct the issue. He also explains that in contracts like PAM 25.1, the employer must follow the step-by-step process. If any step is skipped, the termination could be considered wrongful, which may lead to legal consequences and damages against the employer. Moreover, the video also warns about wrongful termination. If the employer terminates the contractor without valid grounds or without following the proper process, then the employer might be the one in breach, and the contractor can claim loss of profit, damages, or even sue for defamation. One very useful point shared by the speaker is this: termination should always be the last resort. It's better to negotiate and mediate than to rush into termination. Finally, the speaker gives practical advice to always refer back to the contract and consult a professional before initiating termination. Next, I would like to talk about the comparison of the termination clauses under three standard forms of contract: PAM 2018, that clause 25.1, CIDB 2000, that clause 44.1 EA, and PWD 203, that clause 51.1 EA. While each of these clauses is structured differently, they all serve the same essential purpose, is to grant the employer the right to terminate the contractor's employment in the event of certain defaults. So, let's begin with the similarities between the three. All of them provide the employer with the right to terminate if the contractor fails to commence the works on time, suspends the works without reasonable cause, or fails to proceed regularly and diligently. These clauses is to protect the project timelines and ensure quality progress on site. Next, let's look at the differences of each contract. The PAM 2018 contract is more concise and primarily focuses on the contractor's performance and compliance with instructions. One key highlight in PAM is the explicit mention of abandonment of works. If the contractor stops work without cause, the employer has the right to intervene and terminate the contract swiftly. On the other hand, the CIDB 2000 contract is the most comprehensive. In addition to the common defaults, it includes broader grounds such as persistent neglect of obligations and failure to comply with any terms and conditions. Most notably, CIDB 2000 allows for termination for convenience or national interest, meaning the employer doesn't always need a default to end the contract. It also places emphasis on the requirement for the contractor to provide a performance bond. Failure to do so may also justify termination. The PWD 203 contract, which is commonly used in government projects, is more tailored to public works. For example, if the contractor fails performance tests or exceeds the maximum delay damages, these are specific breaches that justify termination. PWD 203 also includes clauses for corruption or fraud, showing the government's strict stance on integrity in public procurement. Now, I want to share two cases about the termination of contract. First, Damansara Realty, Pahang. Stien BHD, Viom Kahaya Mineral Asia BHD, 2027. Case background. This case involves a contractual dispute between Damansara Realty defendant and Om Kahaya Mineral Asia plaintiff. The plaintiff was authorized to conduct land clearing and bauxite mining operations on the defendant's land. However, after completing preliminary work, the defendant unilaterally terminated the contract in September 2015. The plaintiff argued that the termination was unlawful and claimed special damages for wasted expenditure, loss of anticipated profits, or alternatively sought specific performance of the contract. The case went through multiple stages: initial dismissal by the High Court, reinstatement by the Court of Appeal, a damages award by the High Court upon retrial, and finally, an appeal to the Court of Appeal. Court adjournment. The Court of Appeal ruled that the defendant's termination of the contract was indeed unlawful, as it violated the 60-day notice period and lacked legal justification, thereby dismissing the defendant's appeal on liability. However, regarding the Rm 10.8 million damages award, the court found that the plaintiff failed to sufficiently prove wasted expenditure, and the trial judge had incorrectly split the contract into phases to justify the award. Critical issues included: 1. Reliance on unverified Part C documents, 2. Failure to strictly prove special damages, and 3. Lack of contractual or legal basis for the damages amount. Conclusion. The final judgment upheld the principle of contractual sanctity, prohibiting arbitrary termination, while demonstrating judicial prudence toward damages claims no relief without sufficient evidence. Although the defendant's termination was deemed unlawful, the plaintiff received no compensation due to non-compliance with evidentiary requirements. The ruling underscores that special damages must be precisely claimed and proven, serving as a guiding precedent for evidentiary standards in commercial contract disputes. Next, DC Contractor, Stien, BHD, V University, Pertahanan, National Malaysia, 2014. Case Introduction. The plaintiff successfully secured a Rm 4.95 million contract to construct security facilities for the defendant's university, with completion scheduled for January 2012. The plaintiff requested 3 extensions, totaling 192 Yawana 36 days, due to design discrepancies and soil conditions, but the defendant rejected the second extension, citing slow progress, and terminated the contract under Clause 51. The plaintiff argued that delays were caused by the defendant's consultants and filed claims including quantum merit compensation. Court ruling. Invalid termination. The defendant failed to strictly comply with Clause 50, 1 termination procedures, with delays primarily caused by uncoordinated drawings from the defendant's consultants. Time not of the essence. Delays only entitle the defendant to damages, not termination rights. Contradictory dual termination. The defendant could not simultaneously validate both termination notices. Blacklist claim dismissed. The plaintiff provided no evidence of actual reputational harm. Judgment summary. The court ruled in favor of the plaintiff's claims and dismissed the defendant's counterclaim, holding the termination was unlawful. No fundamental breach existed. However, the plaintiff failed to prove damages from blacklisting, limiting recovery to contractual performance-related compensation.